Okay, let's see what's coming from Ginny Anderson.
Honourable Ginny Anderson, sorry. I was expecting someone else to stand up who didn't, and I just got a bit brain faulty. Sorry.
Thank you very much, Madam Chair. Look, I thought it was important. I'm going to go to the preamble, but before I do that, I would just like to highlight that it was back in 2010 that on the 6th of September there was a press release from the then Minister of the Treaty of Waitangi Negotiations, who was the Honourable Christopher Finlayson, and I think it's important to understand the Minister's view of the policy intent under a national government at that point of time. And he states in his press release, one of the key objectives of the legislation is to give Māori the opportunity to argue their case for customary marine title before the courts or in negotiation with government. For that reason, it is inappropriate to second guess what a court or negotiations process might decide. And he also highlights in that same press release that those tests that are being applied, they are test-based, as noted by other speakers, based on overseas common law from similar countries such as Canada, but reflect New Zealand's experience better than overseas case law by incorporating tikanga. Customary marine title is not an exclusionary right and includes the right also of other accesses, and I think that's been one of the misunderstandings. My question to the Minister in relation to the preamble that is currently put out in the bill that we have on the clerk's table before us is given the lack of consultation in this document, in this whole process, has he considered including in the preamble some of the findings from the Waitangi Tribunal inquiry? And I think if we are accurate about reflecting the historical record and reflecting what has occurred in the preamble that is currently laid out in the bill, I would like the Minister to consider whether he would like to include the Tribunal's finding that the Crown has breached the principle of tino rangatiratanga by exercising kawanatanga over Māori rights and interests in Takutai Moana without providing any evidence for one of its key justifications, namely that the public's rights and interests require further protection beyond what is already provided in the Act, and that the Crown also failed to inform itself of Māori interests. I think what is particularly important, and I'm sure this will be traversed again, is the lack of consultation with those people who are directly impacted by this legislative change. However, what smarts even more and rubs salt in the wound is the fact that there was consultation with commercial fishing interests, which have already got statutory protection. Prior to finalising the proposed amendments, while failing to consult with Māori, the Tribunal note that that is a further breach of the principle of good government. Now, as the Minister responsible, I think it's only right and fair for those people impacted, and also for future New Zealanders to understand what actually has gone on right here. It's well and good that we have national ministers turning up to celebrate 50 years of the Waitangi Tribunal, but surely if their research and their findings are valued enough, they should be reflected in the preamble of this bill. And I think it's also important to note that they found that the Crown breached its principles of active protection as well as good government by proposing those amendments. And so, as a result, applicants will be forced to have their cases reheard, burdening them further financially and emotionally as well. So I'd be interested to know whether if the Minister, who's a student of history himself and has a role in recording the history, why will he entertain the fact that we could record those findings from the Waitangi Tribunal in this preamble?
Honourable Paul Goldsmith.
Of course, the difficulty that we'll find, and we can debate this all day, bringing up different quotes from the Honourable Chris Finlayson, and we'll all be able to find one that suits our argument. And I heard the member's quote from Mr. Finlayson. I could give a quote from Q&A on the 20th of June 2010 when he said, in the round, based on the sort of information I have, based on my talking around the place, I'd say about 10% of the coastline would be.
Whoa! Oh, yeah. Sorry,
under CMT. I wouldn't want to be specific about which bay is in, which bay's out. We'll have to issue these things. And further on he says, we're looking at the upper east coast, Eastern Bay of Plenty, way up north, that sort of place. And then I could refer to Mr. Finlayson in this House at question time, answering a question from David Parker on the 16th of June 2010, where he said, Parker said, how much more of the foreshore and seabed does the Attorney General expect will be subject to customary marine titles as a consequence of the change to the threshold test that currently applies to territorial customary right? That change being from to no longer require continuous ownership of contiguous land, which is what the old test was under Labour, while still requiring continuous exclusive control of the foreshore and seabed concerned. And the answer from Mr. Finlayson was, well, that is a very good question, an important question. I believe, in answer to that member, that we're not talking about very much at all. And so we can all find quotes. Sorry, I was getting into my discussion.
Getting comfortable.
We can all find appropriate quotes, but the very clear intention, and if we look at the speeches from both ministers at the time of when this was introduced, they were talking about emphasising that the Act was intended to recognise CMT in specific parts of the coastline. And what we've seen in recent cases, based on the Supreme Court test, is entire coastlines being granted CMT. And so that is why we believe this legislation is required to restore the parliamentary intent, which was high threshold and specific parts of the coastline, not entire coastlines.
Puhana Linden.
I'd love to know what he means by entire coastlines versus part of the coastlines. What is this that they're talking about when it comes to part of the coastlines? Is this like literally what you call it? Have little marker signs put up there? What you call it? Was it settlement, non-settlement, settlement, non-settlement as you go up and down the coastline?
Yes. But it's like, oh god, where to begin with that? Are we claiming entire coastlines? No, I don't think we are. But anyways, I agree with Ginny that, again, I don't care what quote you take from Chris. What I care about is what's written in the 2011 bill, and that's what you want to go back to, and we can look at that bill and go, oh, we can read the original intent, right? And it's there in black and white. It recognizes, it even has the words mana tuku iho, right? So a cultural claim to a legal status with real powers, you know? And we can look at provide for exercise of customary interests in the common marine and coastal area. That means the right to veto development, protect wahitapu, outline how resources should be managed according to tikanga, ownership of Māori artifacts and minerals, except for petroleum, gold, silver, and uranium. You guys get to keep that.
Oh. Yeah.
But you guys get to keep all the nice stuff.
So, should
Thanks for watching. Make sure you're subscribed to our Facebook, YouTube, Twitch, Instagram, TikTok.